Good morning. I'd like to welcome everyone to today's hearings, and good morning to Committee Member Strength, who will be joining us remotely today. Aaron, are you there? Can show us? Yes? Turn your microphone on.
I've got.
Good.
Good morning, everyone.
Thanks for joining us. The Committee of Adjustment is appointed by Council to consider applications for consents and minor variances to the zoning bylaw. Please be advised that any applicant or agent that is in attendance in person at today's hearing for a specific application may leave the hearing once their application has been considered by the committee. Any applicant, agent, or member of the public wishing to address the committee or for a specific application is reminded that presentations are limited to 10 minutes per person. Okay, could I please have a motion to adopt today's agenda? Watson and Sims. And would the Secretary Treasurer please read the resolution to adopt the agenda?
Moved by Member Watson, seconded by Member Sims. Be it resolved that the agenda of the Gravenhurst Committee of Adjustment meeting dated March 21st, 2025 be adopted.
Thank you, and we will call for the vote on that. Please vote accordingly. And that carries despite someone not voting. Thank you. Okay, do any committee members have any comments with regard to the minutes to be adopted today? So could I please have a motion to adopt the minutes for February 21st, 2025? Moved by Ungerman and Sims. And would the Secretary Treasurer please read the resolution to adopt the minutes?
Moved by Member Ungerman, seconded by Member Sims. Be it resolved that the minutes of the Gravenhurst Committee of Adjustment meeting dated February 21st, 2025 be adopted.
Thank you, and again, we'll call for the vote on that. And that carries, and the minutes are adopted. Thank you. Do any committee members have a pecuniary interest in the applications being heard today? Seeing none. I guess none from Councillor Strength. And in accordance with Section 11 of the Committee of Adjustment Procedural Bylaw, I'll now ask if the Secretary Treasurer has received any requests for adjournment, deferral, or withdrawal from the applicant or agent for any application on today's agenda.
None have been received, Mr. Chair.
Thank you. The Committee of Adjustment will today consider 2 new consent applications and 1 minor variance application under public hearings. The Planning Act requires that a public hearing be held before the Committee of Adjustment decides whether or not to approve a consent or a minor variance. The public hearing serves 2 purposes. First, to present to the Committee of Adjustment and the public the details and background to the application, and second, to receive comments from the public and agencies before a decision is made. I'll briefly summarize the procedure to be used. The Secretary Treasurer, Adam Ager, will advise as to when, how, and to whom notice of the public hearing was circulated. The planners, Angela Jakatis or Andrew Clark, or our student planner, Matthew Armstrong, will provide any other information that is relevant to the application and summarize any correspondence on file. From there, the applicant will be provided the opportunity to make a presentation, followed by questions or presentations from the public, either in favor of or against the proposal. Committee members will then have the opportunity to question the applicant, the Secretary Treasurer, the planners, or anyone giving presentations. The proposed consent or variance will then be considered by the committee. If anyone from the public would like to receive a copy of the decision made on any application, please provide your name and full mailing address on one of the forms provided on the table at the back of the room. Would the Secretary Treasurer please advise how, when, and to whom notices of the public hearings were circulated?
Notice of the public hearings concerning the proposed applications were sent by first-class mail to the respective owners and assessed persons within 60 meters of the property subject to the proposed consent or minor variance application and emailed to applicable agencies. Included with each notice was a summary of the application, a site sketch, and a key map showing the location of the property. The circulations were provided in accordance with the provisions of the Planning Act, RSO 1990, Chapter P13.
Thank you. It is important to note that should committee approve any application, there is a 20-day appeal period during which time today's decision may be appealed. During this appeal period, no building permit may be issued or other work commenced. Also, in the event there is an appeal, and in order to be kept advised of a possible Ontario Land Tribunal hearing, members of the public must request to be sent a copy of committee's decision on the application. It should be noted that Bill 23 no longer allows third-party appeals. Only the applicant, the municipality, and certain public bodies will be able to appeal a minor variance or consent decision. We'll now deal with the applications for consent. And I now declare this to be a public hearing for application B07-2025-GR for Sparrow Lake Estates Limited. And I will ask our planner, Andrew Clark, to please provide any additional information that may be relevant.
Thank you, Mr. Chair, and good morning, everyone. There we go. The subject property is located in the southwestern area of the town, on the east side of Sparrow Lake and the north side of Clipsham Road. The property is accessed from Clipsham Road, which is municipally maintained and also has assessed frontage on Sparrow Lake. The property is within the waterfront area and rural area designations and is zoned commercial waterfront, subject to special provisions 98 and 307. The surrounding area includes a mix of smaller residential waterfront lots to the northwest and southwest, which use the property currently for vehicular access. The benefiting property in this application is one of these lots to the southwest, known as 1023 Wianco Road, Unit 2. And this lot, I just marked this on the map with a star on it for future reference. The benefiting property is accessible from Wianco Road and 1078 Clipsham Road, which are privately maintained and also has assessed water frontage in Sparrow Lake. The benefiting property is within the waterfront area designation and is zoned residential waterfront. The property is vacant and generally flat and well vegetated with mature trees. The property does contain private roads that provide access to the abutting waterfront properties, including Wianco Road, which traverses northwest across the property. You can see that line in yellow. And 1078 Clipsham Road, which traverses north on the southwest area of the property. And we will look at that further in our pictures. It's down here. The benefiting property is developed with 2 existing dwellings, a sleeping cabin, a garage, 2 sheds, a shoreline deck and stairs, a dock, and a boathouse. It's relatively well vegetated and slopes downwards towards the water. And surrounding residential waterfront lands are also well vegetated and developed with detached dwellings and accessory structures. An application has been submitted to permit a lot addition of approximately 1.6 hectares of land from the southwest corner of the subject property to one of the abutting residential waterfront properties to the west, which you can now see in the site plan. The benefiting property is highlighted in black. The lot addition is highlighted in red. The location of this severed land is vacant and includes an existing 30-meter wide right-of-way, which has 1078 Clipsham Road on it, which will continue to provide access to abutting waterfront properties and is not proposed to change in this application. The remainder of the lot addition is intended to provide the benefiting lands with additional area for the development of accessory structures, specifically a detached garage. If approved, the resultant area of the benefiting land would be approximately 2 hectares, and the area of the retained land would be approximately 29.2 hectares. This application's also been submitted concurrently with a zoning amendment application, which seeks to rezone the area of the lot addition from the commercial waterfront zone to residential waterfront in order to be consistent with the zoning of the benefiting lands it's proposed to be added to. And that application will be considered by at the March 25th Planning Council meeting. Comments of no objection were received from the Chief Building Official, Deputy Treasurer, Deputy Fire Chief, Infrastructure Technologist, District of Muskoka, and Trent Severn Waterway, and no comments have been received from members of the public at this time. So moving into our site photos, this first image looks north up Wianco Road on the retained property, which is accessible from the publicly maintained portion of Clipsham Road. This is one of the accesses used by the benefiting lands and remains unchanged in this application. This picture also shows that the retained lot is flat and well vegetated. Now moving and looking west, this shows 1078 Clipsham Road, which provides access to abutting waterfront properties, including the benefiting property in this application. This road is on the right-of-way that is proposed to be transferred to the proposed severed lands, the southern end of which can be seen on the right-hand side of the screen. So moving and looking north from the benefiting property now, this shows the other end of the proposed lot addition and right-of-way, which then connects further into Wianco Road moving north. One additional waterfront property to the north uses this right-of-way, which is included in the lot addition. And this looks south down the existing right-of-way towards three other waterfront properties that use it for access. The benefiting lands are on the right-hand side, and the proposed lot addition consists of the right-of-way and then the lands to the left of this image. Now, this looks directly east towards the lands that are proposed to be severed and added to the benefiting property, which are vacant. You can see relatively flat and also well vegetated. Now, this looks west into the benefiting waterfront property, noting existing development and vegetation. And now this looks east from the driveway of the benefiting lands towards the area of the proposed lot addition. So that's the treed area in the background, which does appear functionally related to the surrounding area. So as outlined in the accompanying report, staff are satisfied that the consent application satisfies the requirements of the town's official plan and zoning bylaw, and recommend that the application be approved subject to conditions which will be noted on screen. These conditions include rezoning the proposed lot addition to be consistent with the residential zoning of the benefiting lands, and for the severed and the benefiting lands to legally be merged. And that concludes staff's presentation. Happy to answer any questions. Thank you.
Okay, thank you, Mr. Clark. Do the applicant or agent have a presentation that they wish to make? Please come forward and give us your name and mailing address. Push your button on the...
Good morning, Chair, members of the committee. Oh, sorry, that's loud. My name is Melissa Markham, Planning, 1025 Rebecca Lane, Huntsville, Ontario, P1H2J6. I'm here today on behalf of the owners of the severed and the benefiting lands, which is the subject of the application that you have here before you today. The application proposes to sever the 1.6 hectare portion of vacant land, which is essentially for a lot addition to the existing developed waterfront property. No new lot will be created through the application. As provided by staff, a bylaw amendment application will be required to rezone the severed lands to the residential zone in keeping with the benefiting lands. The concurrent zoning bylaw amendment has been scheduled for the Tuesday's council meeting. My full planning opinion was included in the application that was submitted for the consent and zoning bylaw amendment, and we have read the staff report provided by town planning staff, and the owners of the subject and the benefiting lands agree with the conditions as proposed. Once again, the application proposes to sever the parcel and merge it with an abutting property. The application will continue the existing right-of-way for all the landowners that currently have right-of-way across those lands. It's also to provide additional lands for the benefiting property for a detached garage, which is proposed to be developed in the future. This is conceptual, no application's been submitted, and no concept has been developed at this time. The owner is also working on the consent, and there is also an application for the closure of the shoreline allowance, which will also increase the size of the benefiting lands through that application. Once again, we've read the staff report and the conditions proposed. We agree with everything that's put forward in the staff report, and I'm here to answer any questions that you may have. Thank you.
Thank you for that. Are there any questions or comments from members of the public attending in person? Seeing none. Okay. The staff's recommendation committee is to approve the consent. Do we have a motion to that effect? Watson and motion to approve. Moved by Member Watson and Member Sims. Thank you. And I'll ask Adam Ager to please read the resolution.
Moved by Member Watson, seconded by Member Sims. Be it resolved, having regard to the matters prescribed under Section 5312 of the Planning Act, RSO 1990, Chapter P13, that consent be granted for application number B07-2025 GR, Sparrow Lake Estates Limited, conditional upon the following. a deed or schedule or certificate of consent for the severed lot being submitted to the Secretary Treasurer, including all rights of way, along with a registered paper copy of the reference plan. 2, a digital drawing file reference plan, AutoCAD version 13 compatible, and a PDF version shall be provided to the town, and a fee per lot being created be paid in accordance with the current fees and services charges bylaw. 3, the subject lands be brought into conformity with the zoning bylaw by means of the severed lands being zoned for their intended residential use. And 4, that the proposed severed parcel be added to the abutting lands to the west, and that section 53 of the Planning Act, RSO 1990, chapter P13, be applied to any subsequent conveyance of or transaction involving the parcel of land that is subject to of this consent.
Thank you. Are there any questions or comments from the committee to the, any comments or questions to the applicants or Secretary Treasurer, et cetera? Mr. Sims, do you have? I do have. Go ahead then, please.
Thank you, Mr. Chair. A couple of questions. First, to do the comment of 2 dwellings on the property and what the implications of that might be for the future. And the second one, this is as much from my learning, is that there's a lot of right-of-ways here that affect other properties, and I don't know whether a right of having the lands labeled as a right-of-way means that everybody has a right-of-way to use that property, or is it restricted to the people who require that for access? So.
Mr. Clark, do you want to take a stab at those?
Yes, through you, Mr. Chair. Thank you for the questions. First of all, with respect to the dwellings, we would view those as separate from the application being heard today. There are 2 dwellings which aren't currently permitted by the zoning bylaw, but appears they've existed at a time where they would be considered a non-conforming use. If those buildings, any of them, were proposed to be modified from their original footprints, another planning application process would be needed to be approved, specifically a zoning bylaw amendment, and have to be demonstrated that that would be appropriate. But currently those are existing. They're viewed to be non-conforming and separate from the lot addition heard today. Hopefully that answers that. With respect to the right-of-way question, there is a part on the survey that's been laid out. I saw it on the site plan. I can go back to that. You can see that part right there. And so it's been surveyed out for the purpose of a right-of-way. Not every single property is guaranteed access on that right-of-way. It needs to be registered on title to confirm that. In other words, you would apply for a right-of-way application and the legal work's done to register that, to basically say that you would have legal access over that part. Now, we don't have access to all the title information of every one of those properties. It's assumed that they would have right-of-way access. The benefiting lands there, when we looked at their title, they have legal access over that right-of-way. So it's assuming the other properties would as well, and nonetheless that they use that right-of-way for access. Otherwise, it can be if it's not on the title of the property that guarantees access, then sometimes the owner will verbally allow others to use the right-of-way as well, but that's kind of an owner-by-owner specific scenario. But to have legal access, it would have to be registered on the title of the property that they can use that right-of-way. But this case, that appears the case, and there has been that right-of-way that's been surveyed out and designated for that purpose, for access for those lands directly abutting it.
Thank you, Andrew. That is very helpful, and it just does raise the question in my mind whether we're by approving this, we'd be locking the. I guess there's is there 2 or 3 properties? I'm sorry, I'm just going to look at my map here. Are the 1, 2? Yeah, 1, 2, 3 properties to the south. whether we could be inadvertently locking them in without access to their properties. And if I understand you, that's beyond the scope of this application, because you don't study, you haven't studied or examined the title for those 3 other properties.
So, yes, I would view that separately still to the matter at hand. All properties that have access to that right-of-way legally through their title will continue to have it. If there are properties that don't, it would be up to the owners to guarantee that access, to provide continued access and to maybe perhaps move forward with establishing a legal right-of-way. But that would be a little bit separate. And typically, rights of ways, they're an application dealt with through the town, but they're negotiated between the property owners. But the main thing here is that those properties that have legal access over that right of way will continue to do so, and that area that is used for a right of way won't be able to be developed on and will continue to be surveyed out for that purpose.
Thank you. I'll just add too, I mean, my understanding, I'm not a lawyer, but my understanding is it depends on the right-of-way agreement as well, because some right-of-ways, rights of way are not for vehicular traffic, they're for walking, you know, so it depends on what the agreement says. And I think, as Mr. Clark has said, but any right-of-way is attached to the property no matter who the owner is, because it's registered on title. So did you want to add something to that, Mr. Ungerman?
To the chair and to Mr. Sims, I think when you create this new lot and a description is going to be created for it, it's going to have to contain the right-of-way. So the description itself will say subject to a right-of-way or together with. So as long as the right-of-way's been originally created and registered on title, when the surveyor creates the new legal description by a part on a reference plan, he's going to have to include the right-of-way. So whoever, the benefiting lands that gets the lands we're severing and attaching to, it's going to say it's subject to.
And I'll just confirm, yes, that's correct. And that's partly why the lot configuration is designed in this way, is to include the entirety of that right-of-way, which was surveyed out on the original reference plan for the retained property. So it'll include the whole piece.
Anyone else? Because I have a question. Could we bring up the actual resolution again? Because something just caught my eye that, you know, that the proposed severed parcel be added to the abutting lands to the west. There are several properties to the west. And I'm wondering if that needs to be specific to which land to the west. Is that important, or?
I think typically we are general with the location of that condition, but we always interpret it to be the lands subject to the application, those being the lands shown on the sketch. So, you know, it wouldn't be expected that we get a deed drawn up for another piece of land there.
Yeah.
Because those owners, you know, aren't involved in this application. But we wouldn't accept it for any other lands to be added to except for the lands that are shown on the site plan, that being 1023 Wianco Road Unit 2. But the conditions, it is worded generally like that, but we would, make sure that it would be for that specific benefiting property.
Makes sense. Okay. Mr. Ungerman?
Through you, Mr. Chair, could we bring up the consent, the sketch for the consent application? Yeah, that's the one. So what's not clear to me, because it's just too small, there seems to be, let's say 1, 2, 3, 4, 5, appears to be separate lots immediately to the west of the proposed severed lands. Are we attaching, is the application to attach the severed lands to the second from the top of those 5, which reads Part 2?
Yes,
It
that's
says
correct.
benefiting lands. So I wonder if there's, it looks to me like it's Part 2, 35R, and I'm having trouble seeing it. It's 9096?
Yeah,
9096. So when this, if we approve this application, could there be reference to the consent that the benefiting lands is Part 2 on that plan? Is that the simplest way to deal with your concern? Because I think your concern is a legitimate one. I think it's
Yeah, I mean,
simple answer is though is just
It could also be as, because if you look, there is the little arrows on the, so it could be as the, you could simply say the benefiting lands as shown on the sketch provided, or as part of the
actually
application.
just-
Something like that. I think it's really just a,
when we
wording
receive that condition is typically implemented kind of concurrently with the first one, so that there will be a statement on the transfer that's provided saying that that section of the Planning Act will always apply to make sure that those lands are never separately conveyable. So when the transfer is provided, the correct legal description is going to have to be used for the benefiting lands, that being Part 2 on that survey plan. And as they close their shore road allowance, then there's also the part number for that survey that would be considered. But we would be reviewing that legal description for accuracy at that stage as well, and would have to confirm that it's the right legal description for the benefiting lands in this application. There's always the option to be more clear in the condition, but that's how we have typically done it moving forward in the process, and we ensure that the legal descriptions are accurate through those conditions, including the transfer and deed submitted.
so it is clear through the application process which lands we're talking about. We've got the sketch, we've got the labels and whatnot, so it's up to staff to make sure that,
Correct. Like if there was a part 3 on that survey plan, that was on the legal description,
Yep.
we would review that and say, no, that's not what this application
presumably if
was
the
approved
shore
for.
road closure gets done, this is done all as one, at one time, if the shore road closure is done in time, I would think, as well, before it's registered, as opposed to doing 2 registrations, like,
Yeah, I guess that would partly be up to the applicant
that's-
too.
yeah.
We could fulfill that condition without the closure of the shorelands, but in terms of
Yeah.
simplifying the legal process, that would probably make sense to do before.
but they have 2 years to
Yes,
satisfy the requirements, right? Yeah.
correct.
Okay. No, it's probably something that's been there all along that we've never really discussed. Okay, anything further? And I'll ask the planner if there are any recommendations or comments to bring to the attention of the committee as a result of these proceedings.
Staff would recommend the application be approved, subject to the noted conditions.
Thank you. So we will call for the vote on the resolution. Please vote accordingly. And that carries. Thank you. And I now declare this public hearing to be concluded. Thank you. And moving on, I now declare this to be a public hearing for application B08-2025 GR for the estate of Anna Boyington. I'll now ask the student planner, Matthew Armstrong, to please provide any additional information that may be relevant.
Through you, Mr. Chair. The property is located in the eastern area of the municipality in the township of Ryde. The property is accessed from Barkway Road, a publicly maintained road. The property is designated waterfront area in the official plan. Also, the subject property is zoned rural and is located in proximity to Bass Lake. The properties are located in a residential waterfront area with small cottage developments and dense vegetation visible in the air photo. The application was submitted in order to sever a piece of land that is approximately 0.4 hectares in area from 1798 Barkway Road and add that severed piece to an abutting property at 1810 Barkway Road. The application has been submitted concurrently with the zoning amendment application, which proposes to rezone the retained lot from rural to residential backlot, or RB7. This is being done in order to we're also doing this to recognize the frontage of the retained lot and rezone the severed lot from rural to residential waterfront, RW6F. Also worth noting is the right-of-way visible in this sketch, which will now become part of the benefiting lands. All of the zoning matters will be considered by council at the upcoming meeting next week. Comments of no objection were received from the chief building official, deputy treasurer, and members of the public. So the pictures are taken starting at the entrance to the property. This is standing on the driveway looking towards the water. Visible here is the posted sign and a small shed on the severed parcel. This is another view down the driveway facing more towards the east. Again, the shed is visible in the background. Here's a close-up view of the shed and the remainder of the driveway. This image looks up the driveway towards the road frontage. Visible here is a garage structure on the retained parcel. To the left of the driveway is the retained lot, and to the right is the severed lot. So here is another image looking up the driveway and towards the road. You can see the dense vegetation that makes up this property. This is a view of the cottage on the benefiting lands. You can see the lake in the background along with mature trees. So this is the property to the east of the benefiting lands that fronts onto Bass Lake. It also benefits from the right-of-way from Barkway Road. The change in ownership of the access driveway will not change the legal status of this right-of-way. So this is an image again highlighting the vegetation on the retained parcel. And you can see that the properties are generally level. There are no steep slopes. And the lot reconfiguration will maintain the general character of this area. And here's a final image showing again the vegetation and the level nature of the parcel. Staff are satisfied that this proposal is appropriate and would recommend that it be approved, subject to the recommended conditions.
Okay, thank you. Do the applicant or agent have a presentation they wish to make? Please come forward and give us your name and mailing address, and push your button there. Thank you.
Hello, my name is Ian Shantz. My address is 12103 Quick Fox Lane in Bowie, Maryland, United States, 20720. I am acting both as an agent for the estate of Mrs. Boynton as well as half owner of the benefiting property. Thank you for committee members attending to this and doing your due diligence. I really appreciate that. And to your presentation, Mr. Armstrong. Thank you. Mrs. Boynton passed away this past year. Very sad. She was a wonderful woman. She was very friendly. She was always so accommodating for us. We purchased the property first, built the cottage on there. Afterwards, we had connected with her and visited with her often. Since we do live in the United States, we now spend basically the whole summer, having retired, at our cabin in this property, and we would visit her often. She was very helpful in that we actually applied for an official change of title and an easement for the right-of-way through her property. And so, as you could see from the diagram, it's kind of awkward. She has ownership of this property and then this wiggly right-of-way that goes through the center. After she passed away, again, we have been very friendly with her daughter, Shelley Oram, who is now taking over the issues as far as dealing with Mrs. Boynton's estate. And we proposed to her that we do this severance in order to make the awkwardness of the property less awkward for her. And for us, being the benefiting property, we would then have a more substantive grasp on the right-of-way for future owners that there may be. Adding to that, the other property that has access along this right-of-way happens to be my brother, who is here today. If there are any questions for him, he could certainly answer it. But the easement is also on the title for his property, and that is legally on his title as well. So that the plan is that we will just make the right-of-way and then this weird severed wedge part of our property just in order to make it all work more easily for everybody. So that being said, if there are any questions, I would be more than willing to answer them for you.
Okay, that's good. If committee has questions, we'll bring you back for those. Thank you. And are there any questions or comments from members of the public attending? If so, please approach the podium. And I see none. Okay, committee. The staff. Yes.
Through you, Mr. Chair, if the gentleman can come back up, I just want to clarify on the sketch, is part one owned by your brother?
I would need to see the sketch.
I'll have to put the sketch back up. Part one, I presume part one and the property to the east of it is the lands you were referring to that are owned by your brother?
It would be the white patch in the upper right-hand corner, lot 22.
So part one is owned as part of the property that your brother owns?
Yes.
Okay, so
If that, no, part one actually is claimed by the town. That is the continuation of the right-of-way.
correct.
So part one is officially claimed by the town as well as the shore road allowance on my brother's property. So it's kind of that weird hockey stick shape, you know, the long stick and then the paddle of the hockey stick, which is the shore road allowance,
So
is claimed by the town.
Are you saying that part one and is owned by the town? Wouldn't it be owned by whoever owns, and I guess it's your brother, owns the white section?
Well, I can give you some background on that. Mr. Pillager was actually a relative of Mrs. Boynton, and that whole property was initially owned by him, and then he severed it up into these properties. When he died, that particular strip was intestate. There was no actual documentation on his will. And so we keep calling it, you know, the dead guy's property as the strip that goes down there. So it has been unclaimed for, well, since the 1970s, I guess. And so that the town has basically said, because it's been intestate, we will take ownership of that particular strip. I know it seems very strange, but that is our interpretation of the history, having talked to the daughter, Mrs. Boyington, the lawyers. It all was looked into when we bought the parcels of land in the first place. All seem very strange, but that is my understanding of that strip.
It would have just gone to his next of kin if it wasn't covered. If somebody owned it, whether they died testate or intestate, it would just go to their next of kin. So
So I think Ms. Jakatis has something to add on this?
I'm just, I don't know that it really matters, other than to clarify that based on this sketch, it seems to me that part one, being white, would be part of the lands immediately to the east and north of the retained lands.
One would think, but it
You think not?
isn't.
Doesn't make sense.
Yeah, I mean, there's the road, the shore road allowance is shown there too. But it's not part of the benefiting. I mean, the issue is part one is not part of the benefiting lands. That's all we can interpret from the sketch, I think. And Ms. Jakatis,
But it,
you have something you could add on that?
Oh, it is an issue. We have certainly discussed this a lot over the years. It doesn't have anything to do with the severance from Mrs. Boynton's property today.
but part two of this, part two of the part of the proposed severed lands that is designated as part two would have to be owned by the estate.
It is, by Mrs. Boynton. Yes, so the two, you can see, if you really look carefully, the width is different. They are really two different entities. The first half of the easement is only 20 feet wide, and the rest is 30 feet wide, 10 meters for the white patch there, and the part that Mrs. Boynton owned was only 6 and some odd meters.
So is your brother's parcel only accessible through Bass Lake? It's landlocked?
Well,
So
he
how is it
does have the
accessible?
right-of-way. Similar to the previous case that you folks have discussed, the right-of-way has been, quotes, agreed upon
Okay.
for the owners.
So title to your brother's parcel gives him a right-of-way over Part 2.
Right. Now, keeping in mind that we also are only using Part 2 without legal authority apart from the agreement that it is what we are doing. Yeah. It's interesting.
Okay. I'm fine, thank you.
Ms. Jakatis?
Perhaps I can just add, I'm not sure if any further clarity will be provided. This sketch was prepared by an Ontario land surveyor, and they would do a title search in a situation like this. And I know it's hard to see on the screen, but they both Part 2 and Part 1 indicate subject to a right-of-way, and then it lists the particulars. And I would just note that according to town mapping, Part 1 is town-owned. The bottom line is, we don't know who owns it, and we looked at it and determined that it's not germane to this application, and that by this application would not change any existing legal right-of-ways for the benefiting land or the abutting property, Mr. Shantz's brother. And so therefore, we weren't concerned about needing to determine who in fact owned Part 1.
It also looks interesting to me that Part 1 seems to extend into the original shore road allowance, which makes it even more unusual. But I don't think it has any bearing on, again, as we discussed, any right-of-way still exists independent of who the owner of the property is. Correct? Mr. Sims?
Thank you, Mr. Chair. I'm in support of this. I mean, it's complicated, whatnot. It does raise the question, though, this fact that the town owns that land, is that a driver goes in on Part 2, drives to your property, has some, incurs an injury or damage to a car in a pothole. The town would actually be liable.
Go ahead, Ms. G.
Through you, Mr. Chair. Again, of course, I'm not a lawyer, but if someone were to do that, they'd be trespassing. Part 2 is private land. There's no right for anybody to travel across that any more than there is across any other private driveway.
Well, unless it was someone who did have permission to be on Part 2, because they're on to Part 2, they drive onto Part 1.
We'll let the lawyers deal with that, I think. It's again, I don't think it's germane to this lot addition, is it, Ms. Jakatis?
I would just suggest that the people who have permission to drive across Part 2 are Mr. Shantz and his brother, the property owners that have a legal right-of-way across Part 2. That's who has permission to drive across that property.
Or anyone they invite for a visit. Regardless, I think are we? Sorry, we need, yes, oh, sorry, we were discussing this even before we had the resolution read, correct, so, well, we'll get the resolution on the floor, and then, okay. We'll ask questions after the resolution's on the floor. If I could have someone want to move that? Okay, Ungerman and Watson, thank you. And Mr. Ager, will you please read that resolution?
Moved by Member Ungerman, seconded by Member Watson. Be it resolved that having regard to the matters prescribed under Section 5312 of the Planning Act, RSO 1990, Chapter P13, that consent be granted for application number B08-2025 GR Boyington, the estate of Anna. Conditional upon a consent certificate of the severed lands, including rights-of-way, be submitted to the Secretary Treasurer along with a registered copy of the reference plan. 2, digital drawings of the reference plan, AutoCAD version 13 compatible, and a PDF version shall be provided to the town. A fee for the revised lot configuration be paid in accordance with the current fees and services charges bylaw. 3, the zoning of the property be changed as followed. The retained lot be rezoned to residential backlot RB7 to reflect the official plan designation, which is the waterfront area, and B, that the frontage of the retained lot be recognized at approximately 144 meters. C, the severed lot be rezoned to residential waterfront RW6F to be consistent with the zoning of the benefiting lands located at 1810 Barkway Road, Unit 2. 4, final approval be subject to the town of Gravenhurst confirming that the retained lot remains satisfactory for on-site sewage disposal, and that any problems identified by the town with any existing sewage systems be corrected to the satisfaction of the town of Gravenhurst. And 5, that the severed parcel be added to the abutting lands to the north, and that Section 53 of the Planning Act, RSO 1990, Chapter P13, be applied to any subsequent conveyance of or transaction involving the parcel of land that is subject of this consent.
Thank you, Mr. Ager. Now, are there any further questions or comments on this? Mr. Watson, no? No? Okay. We're good? Okay, and I will ask the planner if there are any recommendations or comments to bring to the attention of the committee as a result of these proceedings.
No comments have been received. Thank you.
Your recommendation is still to,
The recommendation is to approve the application,
yes,
yes.
thank you. Okay, so we will vote accordingly on this application. And that carries. Thank you very much, and I now declare this public hearing to be concluded. And we'll now deal with the application for minor variance. And I now declare this to be a public hearing for minor variance application A03-2025 GR for Pellegrino Manja Casale. I will now ask the senior planner, Angela Jacatis, to please provide any additional information that may be relevant. And I hope there's no rights of way involved.
Thank you, Mr. Chair. I just need the PowerPoint. This property is located west of the urban center on Parker's Point of Lake Muskoka. The property is accessed from Parker's Point Road, a municipally maintained road. The property is designated waterfront area in the official plan and is zoned residential waterfront RW6D in the zoning bylaw. The property is located in a residential waterfront area. You can see in this air photo that the dwelling is currently located quite close to the water, and that will be discussed further as we go along. This photo shows, again, the existing site plan showing the dwelling and located quite close to the water, as well as the shoreline development that is the subject of this application, specifically the floating dock, which is the U-shaped dock in the sketch. So then moving to the proposed site plan, you can see that the shoreline development remains as is existing. So the proposal is to recognize the existing dock, which results in shoreline development of 128.8 square meters, where 69 square meters is permitted, representing a variance of 59.8 square meters, and also to permit a maximum dock width of 11.7 meters, where 6.5 meters is permitted, representing a variance of 5.2 meters. Comments of no objection were received from the town's Emergency Services Department and Deputy Treasurer. The town's infrastructure technologist has requested an entrance permit, and the chief building official has requested the issuance of permits for the docks. So both of those comments by the chief building official and the infrastructure technologist are incorporated as recommendations for the approval. No comments were received from members of the public. So just going through some pictures, this first picture is taken near the road, looking south across the property towards Lake Muskoka with the dwelling visible. And again, an important aspect of this application is that the applicants are proposing to remove the existing dwelling and rebuild a new dwelling that is set back an additional 10 meters from the water. So the proposed new dwelling will be located behind the existing in this open and flat area shown, and this is looking north on the property towards Parker's Point Road. You can see just sort of see the white car and Matt standing on the road. Just turning again, looking back towards the dwelling, this photo shows the shed, which is behind the dwelling. It's to be removed, and the side yard setback of the proposed new dwelling will be improved as there's encroachment into the existing side yard. Then moving around to the lake side of the property, looking back at the existing dwelling, again, it's only 8 meters from the water with really no vegetation buffering in front. There are the two large trees to the side. And then looking across the property, you can see the neighbor's property the neighbor's dwelling to the east. And you can see at the back of this is part of the dwelling, and I just point this out because the setback of the proposed new dwelling will be beyond this. So the proposed new dwelling is moving back substantially on the property. So this is obviously an improvement to move that dwelling back, as well as an opportunity to improve the shoreline buffer through revegetation. This is the dryland boathouse, which is part of the shoreline development. You can see the neighbor's adjacent boathouse and some other shoreline structures farther along the point. And what I'm standing on, you can just see sticking through the snow, is a portion of the shoreline deck that is also part of the shoreline development. Unfortunately, the snow and ice cover made it impossible to properly see this structure or the dock that the relief is required for. So you can just see what I assume is a dock cleat sticking through the ice. But for that reason, aerial photographs were used as a point of reference, and that's what determined that the floating dock was installed sometime between 2013 and 2018. And the only other thing I would point out on this photo is that the property is located on a large open bay of Lake Muskoka. So then turning and looking to the west, again, just an indication of some of the shoreline structures, including docks and boathouses. Docks are harder to see because of the snow and ice cover. And then this photo is turning and looking at the neighboring properties to the west, and again, intended to show that the proposed new dwelling will be more in line with neighboring structures and will also seek to add some more vegetation. So this being the final photo, I would just point out that as with all variances, each property is looked at on a standalone basis, it's evaluated on its own merits. And the most important aspect of this application is the opportunity to make improvements to the shoreline buffer through a renaturalization plan in order to mitigate the increased shoreline development. So it is staff's opinion that this opportunity results in a better outcome for the property. And I would also point out that based on the recommended conditions, if the dwelling is not moved back to 18 meters, the dock is not permitted to remain. So with that in mind, staff are satisfied that this proposal meets the 4 tests of a minor variance as outlined in the staff report, and would recommend that the application be approved subject to the recommended conditions, which include the requirement for a new dwelling to be moved back, and the submission of a renaturalization plan of the shoreline buffer area, as well as an entrance permit and building permit as per the comments that were received. Thank you.
Thank you, Ms. Jakatis. At this time, I'll ask for comments from the applicants, Joanna Pellegrino and Rena Mangic-Sale, who have pre-registered to address the committee electronically. Please ensure that your microphone and video are turned on, and go ahead and press the talk button or icon.
Good morning, everyone.
Good morning.
Just representing ourselves, I'm Rena Mangic-Sale.
I'm Joanna Pellegrino.
And I believe that we just, for new property owners for almost a year now, we just want to ensure that everything is permitted as the way that it is, and we're willing to do what we need to do to ensure that that remains as per the town's requirements.
Okay, thank you. If there's nothing further, we will ask any questions we may have later. And, oh, sorry, does the agent have a presentation they wish to make? Or- Okay. That's fine. And are there any questions or comments from members of the public? I don't think we have any left, do we? Yeah, sorry. Okay, committee, the staff's recommendation is to approve the consent application. Does committee have a motion to that effect? Watson and Ungerman. And I'll ask Mr. Ager to please read the resolution.
Moved by Member Watson, seconded by Member Ungerman. Be it resolved that application number A03-2025 GR Pellegrino and Mangiascali be approved, and that the necessary notice of decision be prepared conditional upon the dwelling be set back a minimum of 18 meters from the optimal summer water level, a renaturalization plan of the shoreline buffer be incorporated into a site plan agreement, an entrance permit be required as part of the site plan agreement process, and that a building permit be obtained for the floating dock and crib dock.
Committee, are there any questions to the applicants, Secretary Treasurer, the Senior Planner, or any persons? Mr. Ungerman, go ahead.
Through you, Mr. Chair. I'm just wondering, is it just a formality to get these 2 permits? Through Angela, it's just a formality? Or do they have to do anything other than apply?
Thank you for that question. I don't know that answer. Again, because the docks were installed without a permit, and prior to the existing owners, the chief building official will determine what information is required to be submitted with the application. And I would just also point out they won't get any permits for the docks until the dwelling permit is issued as well for the new dwelling to be moved back to the 18 meters. A floating dock, typically there isn't a lot of information required. The dock that's the shoreline deck, there may be some more details that's required, but that will be up to the chief building official to determine.
Okay, thank you.
Mr. Sims, go ahead.
Thank you, Mr. Chair. I guess the question through you, is looking to the future. And this is, I imagine even the new owners would be thinking about this. In years to come, if we, let me back up a bit. I'm in support, very much in support of moving the dwelling back. I think that's all very positive and supportive. The waterfront is overbuilt, though, I think, as is apparent from Angela's description. Going forward, let's say 5 years, 10 years, if we were to approve this, would the owners be able to then overbuild again if they were to apply?
Mr. Caddis, go ahead.
Thank you. It's a good question. I think the way the decision can be worded is as shown on the attached plan. So it would only apply to the existing structures so that they wouldn't be able to take that number and apply it in a different way. So it would only be able to apply to the existing structures. So they would have reconstruction rights for what's there right now.
I'm not sure I fully understand what reconstruction, the rights comment was. If this is, looking to see if I wrote the number down. The width of 11.7 is presently 11.7 meters with 6.5 meters permitted. So should in 10 years' time a new dock be required for whatever reason, which of those two numbers would be applied?
Thank you. If the application is approved today, then the 11.5 would be applied as it applies to the current configuration.
Okay, clear on that? Sure, come forward. We'll need your name and mailing address and all that then. And push your button.
Mike Winstone, 1060 Wigwam Lodge Road, Kilworthy, Ontario. I'm the designer for the project, and this all came to light because of just the fact that ultimately we were applying for site plan approval and realized that there was no permit for the dock previously. So that's kind of how this all came to be when we found out. The other thing I'll just kind of point out is I know the bylaws are very black and white, but in terms of the building width across the shoreline, the straight line frontage of this property is 29 meters. 30 meters is the threshold to kick it from 6.5 meters to 12.5 meter shoreline width development as well. So we are still, even the 11.7 is still, in theory, ratio-wise, if they had 30.1 meters, we're building 1 meter less than what would be permitted on a lot slightly larger, if that makes sense. So in terms of, I know it's black and white, but in terms of reference and ratio, if they had 1 more meter of shoreline coverage, they could build to 12.5 meters of shoreline width. Yeah, so that was all I wanted to just point out, yeah.
Thank you. So just under the requirement that would permit a wider one anyway. And Ms. Jakatis is nodding her head, so is in agreement with that. Okay, anything further on this? And I'll ask the planner if there's any recommendations as a result of these proceedings.
Staff would recommend that the application be approved with the recommended conditions, as well as an indication, in the decision stating that the shoreline structures are permitted as shown on the attached sketch. So it's very clear that the provisions being granted are tied to the existing structures that are there now.
Okay, is that in the resolution or? Go ahead, Mr. Yeager.
No, through you, Mr. Chair, it would be done in the notice of decision. So I think just based on the proceedings that were here today, we took time to hear the discussion, and it's worth noting that based on the comments from Member Sims, that the necessary notice of decision specifically include that language.
Okay, are we clear on that? Okay, good. We will call for the vote then with that other condition. And that carries. Thank you. And I now declare this public hearing to be concluded. And the next Committee of Adjustment meeting is Friday, April 25th, 2025, which would be a change from our normally scheduled meeting on the third Friday of the month due to Good Friday on April 18th. And as there is no further business, could we have a motion to adjourn? Moved by Sims and Ungerman. And do we have to vote on that? I guess we have to vote on that. We'll vote on that. And of course, that carries, and I now declare this hearing to be adjourned at 10:06 a.m. Thank you.